Okay, looks like that's on the air. Let me get ready.
Okie dokie. You just say, tell me when.
I I think I'm gonna mute my machine and you can start in about 30 seconds.
Okie dokie. Welcome to the monthly Consumer Issues Program hosted by Cornell Cooperative Extension, Tompkins County. On the second Thursday of the month, we're joined by New York State Assistant Attorney General Michael Danaher, who makes a presentation on a topic of consumer interest. Today, he will talk to us about home improvement scams. After his presentation, Mr. Danaher will answer questions that viewers have submitted to CC Tompkins in the Zoom chat box. This presentation also will be available on the CC Tompkins YouTube channel and will be broadcast next month on Mondays on Public Access Channel 15. Thank you for joining us today. And now here is New York State Assistant Attorney General Michael Danaher with today's program.
Thank you, Sandy, and good morning, everyone. Welcome to our Consumer Issues program dealing with home improvement contracts. This is the perfect time of year for us to start talking about home improvement contracts because the weather's finally starting to turn and people are making decisions of whether or not they need to or want to have home improvement work done on their house. And there are specific rules in the state of New York involving home improvement contracts, I think principally as a result of problems that occurred prior to the home improvement contract law going into effect. I don't know the exact date, but it was tens and tens of years ago of consumers not knowing what they're getting, paying too much for it, and contractors not coming in and doing the work. So the legislature stepped forth and created a law that surrounds home improvement contracts. That law was recently modified, which I didn't realize until this morning when I was preparing for this presentation, that it tweaked it a little bit to add roofing, a separate section dealing with roofing contracts. I submit that to some extent, roofing contracts were already included under the statute of a general home improvement contract, but there's more specifics related to roofing contractors that will be good for consumers as well as any roofing contractors who may be out there to know about the law and what is required there. So in New York, we have the statute called the Home Improvement Contract Law, and it covers all types of home improvement work. The definition is so all-encompassing that I suggest that you just assume if it involves your home with a contract for some remodeling work or anything like that, that it would be covered by the home improvement contract law. It would cover driveways, covers landscaping, it covers swimming pools, those sorts of things that are put on land that are owned by the homeowner. Contractors. It doesn't take much to fall within the definition of a home improvement contractor. It would be any home improvement contract for a contractor whose the total price of all jobs that this particular contractor is doing within 1 year amounts to $1,500 or more. And for anybody that's engaged in the last 10 years or 20 years and in a home improvement contract or something to do with their house, it doesn't take much to meet the total $1,500 threshold. So it could be 3 $600 contracts that a home improvement contractor engages in over the whole course of a year with all different consumers, all different homeowners. If you have 3 contracts that total $600, small jobs, in my mind, you fall under the home as a home improvement contractor under the law. It covers all work done by a contractor in excess of $500. So it was, if you had 3 contracts of $501, you'd be a home improvement contractor, plus each and every contract constitutes a home improvement contract. So if you're a large contractor, let's say your contractor has done $10,000 worth of total home improvement work over the course of a year, but you then have a contract with a homeowner for $400. It's not a lot of work there, but a $400 contract, it wouldn't fall within it as a home improvement contract because it's under the $500 threshold. There are also some exclusions. It does not include cosmetics, so it wouldn't be carpets and drapery. Those sorts of things don't fall within it. It does not include appliances either. It may include the electrical work to install an appliance, but it doesn't cover the appliance itself. Interestingly, it also covers a, quote, custom home. A custom home is a new home built on land owned by a homeowner at the time of the contract. So if you're building a custom home on the homeowner's property that the homeowner owns, separate from building a spec home on land that the contractor, him or herself owns, that's then later sold. But if it's built, stick-built home on property owned by the homeowner, it does also include a home improvement. It falls under the home improvement contract law. But incidentally, many of the laws under the home improvement contract law require a written contract. I would think that someone that's going to have a custom built home on their property, they're going to want a written contract anyway, but the law requires that it be. So first and foremost, under the home improvement contract law, if you fall within being a home improvement contractor and the job is a home improvement contract, the law first and foremost requires that all home improvement contracts must be in writing. I can't emphasize that enough. There's been complaints that we've received throughout the years that people have complained to us, consumers have complained to us, and they didn't get anything in writing ahead of time. Well, that to the extent that the homeowner should be getting these things in writing to protect his or her own interest in the property, that's a shame on you. But under the law, it's a shame on the home improvement contractor, because the home improvement contractor is the one that's obligated to provide the written contract. The homeowner is not, but the homeowner should be insisting that there be a written contract for any home improvement contract or any home improvement job. So first, it's the law. It must be in writing. There are heavy penalties for violation of the law that we'll talk about in a little while, but home improvement contractors, you must get it in writing. You must furnish the homeowner with a written contract. If you don't, it's a violation of law, subject to significant penalties. And as a practical matter, it just makes good business sense. If you're the contractor, you want it in writing. You want to have in writing what it is that you propose to do to the homeowner. And the homeowner should insist and want something in writing. Shame on you, homeowner, if you go, don't worry about it. We'll talk about it. We'll figure it out later. No, get it in writing, and it should be upfront. It makes good business sense. It doesn't just protect the homeowner, it protects the contractor. The contractor should have something in writing so that he or she can point to what it is that was required. This is what I obligated myself to do. So when a homeowner says, well, you didn't do this, you didn't do that, you can pull out the written contract and say, I wasn't supposed to do this. I wasn't supposed to do that. See, right here is the exact scope of the work that's being done. So there's a tremendous number of problems or complaints that we've received over the years that if everything was in writing, and it has been, there have been contracts that are in writing, we get a complaint from a homeowner, and then we send the complaint as a part of our mediation process to the contractor. The contractor replies and says, wait, here's a copy of our contract. That complaint from the homeowner says that we were supposed to do this, this, and this. Well, here is our contract. Contract does not call for us to do this, that, or this. It only says that we're supposed to do this. And that resolves the whole problem. Solves the whole problem. It's not what the party agreed to. So it just makes good business sense to have. How many problems would be resolved, complaints that would be resolved if everything that was supposed to be done was in writing and there was a copy on both sides' part, and then both parties can look at it and they can say, hey, this was supposed to be done or not be done. The homeowner could say, before I complain, I want to see this, I want to review my contract, make sure everything is in there. And you look at, oh, lo and behold, they weren't supposed to put up doors in these particular rooms or whatever other thing it was. So it should be in writing. It'll resolve most issues, especially if the contractor includes details on every step and every item that's supposed to be performed. I add a caveat to this as well, not a caveat, an addendum to this, which is all change orders should be in writing as well. It just makes sense. If a homeowner comes to the contractor and says, look, I'd like to change this around a little bit. I'd like the doorway put over here. Can you do this doorway? I've seen instances where the contractor says, oh yeah, we can do all that. And then at the end presents an additional bill for moving that doorway over. And then the homeowner complains, says, you added this thing onto me. Well, there was a change order. How easily would this be resolved and disputes taken care of if the contractor says, you know what, I can move that. We can move the doorway, but there's additional labor and expense, materials that are going to be used for doing that. So it's going to cost another $500. Put it in writing. Change order, whatever date it is. Say, move doorway from right side of the room to left side of the room, install door, whatever, $500. And yet both parties sign. Then everybody knows there's no dispute. It's going to be $500 more and be all taken care of. So change orders, put them in writing as well. So the law has certain requirements on the writing. What has to be included in it? One is the name, address, and phone number of the contractor. I've received a lot of complaints from consumers that they attach the proposal to the complaint form. It was the proposal that the contractor gave, and it doesn't have contact information for the contractor. It doesn't have the address. I suggest that the contractor should put in more than just a PO address. Put your physical address of where the contractor is located. Put the name. I suggest also that you put the name of the principal of the contractor. So if it's Ithaca Housing Development Company, Inc., I would put down Tom Smith, proprietor, Tom Smith, owner, or something like that. So people know who they're dealing with. So name, address, phone number of the contractor. The dates when the job will be started and the date when it will be substantially completed. Put in, when are you going to start? Many complaints that our office has received, contractor never showed up. But the contract never said when the date was that they were supposed to show up, and we invariably sent out the complaint, and the contractor replies saying, I told the homeowner that I wasn't going to be able to start until I finish these 2 other jobs. And the homeowner knew that. Well, put it in your contract. You have 2 other jobs, estimated starting date, August 1, 2022. Put it in there, because then we have a date when it should be started and when the homeowner can start getting nervous if it hasn't been started yet. And the date when it'll be substantially completed, you can say start August 1, completion September 15, 2022. And it's substantial completion. So it's got to be generally substantially completed. There might be a couple of items that need to be finished, but the substantial completion date. You need to include a description of the work, including any materials provided. You're having new garage doors installed. You should have the date when it starts, the date when it's going to be completed, maybe all be done in one day anyway, and then have install garage doors, 2 garage doors on the property, installation of and name, put in a description of what particular garage doors are being used. There must be a notice to the homeowner of a possible lien law or mechanics lien placed on the property if not paid. So you've got to put in there, if you plan on filing a mechanics lien, if you're not paid, you need to put that in there. If it's a big job, my experience has been if it's bigger jobs, it's going to take a little while to get done. And there may be a requirement of periodic payments over the course of the construction project. And you need to list the draw schedule and define when the draws will be made. So usually we will see that, it's 5% or 10% at the start of the job. And then after the addition, let's say it's an addition, after the addition has been framed in and enclosed, then it might be like 30%. And then there might be another draw at another progression of the work, which should be defined in the contract, what it is. And then final payment upon substantial completion, issuance of certificate of compliance. You need to list when those draw schedules are out. It also must include that the homeowner has 3 business days to cancel the contract. Those 3 business days would begin at the time that the notice is furnished and acknowledged by the homeowner. The 3 business days applies in every home improvement contract, except in the case of an emergency. And that emergency has to be detailed in the contract in the homeowner's writing. So let's use our classic example. It's the middle of winter and the furnace goes and you need a new furnace. You don't want to wait the 3 business days, and the contractor wants to help the homeowner out and get it in prior to the 3 days. What has to be in writing is in handwriting. The homeowner says, this is an emergency because my furnace needs to be replaced and I'm willing to waive the 3 days of right to cancel and not cancel in order to get the job done today. Put that in writing. Otherwise, there's a 3-day right to cancel. Now, one thing I've seen in contracts that contractors need to avoid, they can't make everything an emergency. If the contractor still wants to just get it started to get it done, that 3 days can't be waived because it's not an emergency. It's just the emergency of the contractor saying, I have an emergency, I want to start today. That's no good. It's got to be a legitimate emergency written in the homeowner's writing. And I've seen in contracts where the contractor just put in, homeowner agrees to waive 3 days, right to cancel because this is an emergency. No, it has to detail what the emergency is, and it has to be supposed to be in the homeowner's writing of what the emergency is. So there is a 3 business days to cancel. The 3 days doesn't start to run until the notice is given. So contractors, you don't want to start this job until the 3 days have expired and you've given the notice and the homeowner has acknowledged it, because you can get into a situation where you do work, you never gave a 3 business day notice, and about 2 weeks into the job, the homeowner comes to you and say, I'm rescinding the contract. Then you're stuck because you've already spent money and time and effort on this job, and you run the risk of the job having been canceled. So get it done ahead of time. You also now, recent change in the law in the last year or two, you must disclose in the contract information, including contact information, which is the name and address of an insurance company that may be providing property or casualty insurance for the work being done by the contractor. Before, it used to be the contractor said, yeah, I got insurance. You have to put in the contract who the company is and what their address is for any liability or property damage coverage. So that's required. Let's morph over a little bit to this new statute, the new statute provision that came out dealing with roofing contractors. There's a separate subset now in the statute that calls for protections of roofing contractors. It's actually 771-B of the New York General Business Law. Again, it falls under the home improvement contract article, but it's a separate section. So roofing contractors, you're now required under this particular provision, because repairing a roof would be a home improvement contract anyway. You're still covered by the other law that required the contract to be in writing. But here it says roofing contractors, you must have a written contract and you must have insurance. You must have insurance. You have to have insurance and put down in the contract who the insurance company is and their address. You must have insurance for liability, workers' compensation. First of all, you must have to cover your employees, must have it. Second of all, you must have liability and property damage coverage. And in this particular statute for roofing contractors, you must have certain limits on your coverage, which is $100,000 in liability coverage for one person injured as a result of your work, or $300,000 and $300,000 for everybody.
Recording in progress.
That's been injured. So it's 100,000, 300,000 coverage for liability. And you must have $50,000 in coverage for property damage. So let's say you in doing the roof work caused other damage to the home. You must have coverage of $50,000 to cover that, and it must be included in the written contract. Also, interestingly, with a roofing contract, the law provides that you may not recover a deposit. You may not get a deposit. Let's face it, roofing jobs are relatively quick, a couple of days maybe to do that. And so no deposit can be received ahead of time according to the statute. So I throw that out there as a warning to the roofing contractors that are out there. So those are the contract details that must be included in the contract. Here are a few other things. One is the law specifically provides that any money received for work prior to it being performed are considered to be trust funds. Again, we're talking separate from roofing contractors because the statute now says you can't have deposits, but for other home improvement contracts, any funds received for work to be performed later are trust funds, and that's a very serious issue. You have to treat the money as if it still belongs to the owner. Although the homeowner gave you a deposit, you have to treat it as if it's still the homeowner's money. It's not your money, which means you cannot commingle that money, meaning put it with your other money that you have. you should maintain a separate escrow account, separate trust account, I suppose. It just has to be a separate account that you only put prepayments in. So it's, somebody gives you a 10% deposit for a remodeling job. You need to keep those in trust funds. Keep them separate from your general bank account that you have. It's very easy. Just set up a separate bank account that you put in all deposits that you receive. And then you can only withdraw the money from that trust account and put it in your general account to cover things that you have already spent. So it has to be for items that you spent on this particular job. So you put it in trust funds. Let's say you bought some supplies and the supplies have to be paid for. You can take the money out and put it in your general account and pay it to the supply house for the plumbing supplies or whatever. And you must keep records. Keep records of what those funds were used for. It's not your money. It's still although you put it in your own separate account, it's not your money until it's been used. So open the trust account at a bank and withdraw according to the draw schedule. So if you have a draw schedule in your contract, you put the deposit over in the trust account, and you've reached that first level of work to where you can take your first draw, because you're doing remodeling and it's all, and the addition is all enclosed, and that was what the draw schedule called for. And it said that you get to take 20%. Let's just say it's a $100,000 job. So you can take $20,000 when that stage is completed. Once that stage is completed, if it were me, I would have the homeowner sign off, 20% complete. And then you go into the trust account, you take out the $20,000 and you put it in your general account. So that's fine. That is for the purpose of protecting the homeowner, to make sure that only the work that gets done gets paid for, and only this particular job is the one that gets paid for. We had a lot of problems in the past prior to this law where contractors still had to finish job 1, but they've already gotten paid for job 2 from somebody else for their next job. And they kind of ran out of money on job 1. So they take money from job 2, the deposit that homeowner 2 paid, and they used it to finish job number 1. That is completely against the law. Cannot do that. You have to use job 1 money for job 1. Job 2 money has to be set aside and only used for job 2. Any payments received prior to substantial completion must go into escrow. It must be deposited within 5 days of being received. So if a homeowner pays a contractor a deposit, within 5 days, the contractor must put it in this separate account. And it must be in a bank or financial institution located within New York in order to do that. Unless the contract contains the name of the bank, name and address of the bank where the trust fund monies are being held, that within 10 days of making the deposit, the contractor must notify the homeowner where those funds are being deposited. So it makes sense. Contractors, just put it in your contract. Just put a general provision of any deposits are paid or held at Tompkins County Trust Bank or whatever at this address. And then it's in the contract. You don't have to worry about it afterwards. Also, contractors, you must keep records of the separate deposits for each separate customer. So what that means is you just need one trust account, one separate account that all of your customers' deposits go into. You don't have to open up a separate account for each customer. It's just you have one account, but only deposits go in there from all the customers. The important thing is you must keep very detailed records of whose money is going in there. And when a withdrawal is being made, you need to have detailed records of whose money is being withdrawn and what is it going for? So a word to the wise, keep those records, because if one, you withdraw money in excess of the contract amount. So if you withdraw, it's $100,000 and you withdraw $110,000 from your escrow account to pay for that job, well, it's more than what the contract was. So if you withdraw more than that, it's presumed that you mishandled the funds that are in the escrow account. A failure deposit money paid in advance of the job, as well as withdrawing more money than what the contract was, or more money than what a particular consumer had given to you, it is a crime. It's a felony. You can be arrested, you can be charged for a violation of New York lien law that makes it a felony for misappropriating funds. That's exactly what happened. So it's presumed that, one, if you don't maintain records, it's presumed that the funds have been mishandled. And then if you use more money or don't ever deposit the check into trust funds, then it's a crime and you can be arrested. Now, we talked about what is required in the contract itself. There are violations for fines for just violating the home improvement contract law, not getting things in writing, not putting in what you need to put in the contract as required by law. There can be fines up to $2,500 per violated contract. Technical violations can go up to $100 a piece. So you didn't put your address in, it can be a $100 fine, civil penalty. This is in addition to any restitution that would be owed to the consumer. And in addition to any criminal penalties if you violate the trust funds law. So be wary of that. Understand what the law is if you're a home improvement contractor and if you're a homeowner. Get things in writing and handle things properly. Our office is also allowed to step in to bring a case against a contractor who violates the home improvement contract law. I'll tell you, based on my lengthy experience in the Attorney General's office, where I brought a lot of home improvement contract cases, that where we can establish that a contractor is engaged in repeated and persistent illegal, fraudulent, deceptive conduct, we have jurisdiction to bring a proceeding to punish the home improvement contractor who's repeatedly violated the law. Interestingly, the jurisdiction in the statute is also given to the town attorney or a city corporation council or other municipality law enforcement officer, that they have authority to enforce the provisions of the home improvement contractor law. This is a prime area of complaints that our office receives. So there's some words of advice and guidance to homeowners that might be helpful when you're thinking about having a home improvement contract. One is, don't pay unreasonable advance fees. And when I say unreasonable, a significant portion of the total contract. So if a contractor is looking for 50% of this $30,000 job, $15,000 upfront, I'd be very wary about that. And I'll tell you why. One is, most contractors have relationships with their supply houses where they're given a period of time within which to pay for purchases on jobs. So they don't need all the money up front. Maybe they have 30 days or something like that. Let's say you have a job that's $30,000. It's going to take a month to complete. They may not get a bill for one pipe or one electrical wire for 30 days anyway. So there's no sense having $15,000 up front. Sometimes you see the significant heavy down payments that are required are for contractors who have problems with their supply houses and who the supply houses won't give them credit. You don't want to deal with that contractor. So be wary about heavy heavy deposits there. Negotiate the schedule based on completion stages. So if it's a $30,000 job, it's going to take a month to complete. Maybe you have a draw schedule where a certain percentage will be paid after the first week, which a certain amount of work will be completed. I think the best way is to gauge it off a percentage of completion of the tasks that have to be completed on the job. Negotiate that ahead of time and make sure that the payments are paid over a period of time based on that completion. The other great thing that consumers should do is get estimates. The estimates should have specific materials and the services that are going to be provided. And like we talk about frequently here in our sessions with Cornell Cooperative Extension, as a consumer, the homeowner should know what it is they want done. Know ahead of time what you want done. Don't be convinced by someone else what you want done. Know what you want done ahead of time, and then you can negotiate from there. So get the estimates of exactly what it is that's going to be done. Another thing that a good consumer would do is get references. Get references on the contractor that's going to do the work for you. Go to other places that this contractor may have done work with. Speak to those homeowners and say, hey, well, how was your experience? Was the contractor receptive to your inquiries? Did they get back to you? Do they show up on time? Do all of those things. Do your due diligence. Also, find out if the contractor is insured. Now, as we have it with the new law, the amendment to the statute, if they have liability and property damage insurance, they've got to include that in the contract. They got to put in who the insurance company is and make sure that it's in the contract. Find out if they have the insurance. Find out what kind of insurance it is. If they have employees, make sure to see that they have workers' compensation insurance and ask for proof of insurance. Get all guarantees that the contractor makes in writing. Again, I think it protects the contractor as well. Whatever promises you're making, put those in writing. It protects everyone. Get it in writing. Don't do anything orally. Check and see if your contractor is licensed. Now, in our area, I'm going to say Southern Tier, Central New York, there are no requirements, no general requirements of licensing by home improvement contractors. There are licensing requirements in certain municipalities for certain trades, plumbing, electric, those sorts of things. There might be licensing requirements in a municipality. Check and see if they're doing plumbing or electrical work or wherever there's a certain trade that needs to be licensed. Make sure they're licensed with your municipality and they can do that. Some area of the states, however, do have required licensing. Those are mostly, I would say, in the downstate area. It would be counties in Long Island have requirements, and the interesting thing with that is in those particular counties, New York City has a requirement. Suffolk, Nassau County, Westchester, Putnam, and Rockland County, so more downstate, those of us, they have certain licensing requirements that you can't do home improvement contracts. You can't do the type of work unless you're licensed within that particular county. And I've heard anecdotally from my colleagues in Long Island that if a home improvement contractor is not licensed and does work, they can't force the homeowner to pay them. They could turn around and sue the homeowner, and if they're not licensed, it's going to get thrown out because they need to be licensed. We don't have those requirements. Upstate New York, it goes on a municipality-wide basis. So know what work you want to get done. Know what permits are needed. Some permits are required, like you're going to put an addition on or something. You got to have permits for those sorts of things. Make sure you as a homeowner know which ones require a permit, and then have in that contract with the contractor who's responsible for getting the permit. Usually a contractor will go ahead and do that, but they have to have drawings and things for certain types of home improvements, like the specs for the addition on the house they need to do. Make sure you know who's going to get it. Make sure you know if it needs to be or not. Never pay the full price up front. We talked about that. Put everything in writing, know what your payments are going to be, and never do business with a contractor who's unwilling to abide by any of these types of restrictions. So those are the types of guidance that people should be thinking about. Okay, so if you have a problem with a home improvement contractor, one, try and speak with the contractor. Two, you can file a complaint with our office, New York State Attorney General's office. We take complaints. We cannot represent individuals, but we have a mediation program whereby we take the complaint from the consumer and we send it to the contractor and ask the contractor to respond to us. That resolves a lot of the consumer complaints that come in, or consumer issues. We get the complaints, we send them out, the business responds usually, and hopefully there's a way that the deal can be worked out. The other item is you can check with the municipality to see if they have a process where they can inquire of the home improvement contractor to see if there's any violations. Maybe there's a violation of a local code or something, and maybe they can at least contact the contractor for maybe a violation on the plans that were submitted for this particular job. I know also down in our Binghamton area, we have the Southern Tier Home Builders and Remodelers Association, which many home contractors are members of, and they have a process where they can contact their member, who would be the home improvement contractor possibly, to try to resolve a particular dispute. But you can feel free to contact our office, and we will try to assist you. And also the other thing about it is that I mentioned earlier that we can bring proceedings and have brought proceedings against home improvement contractors who have repeatedly and persistently violated the law. It hasn't been just one homeowner that has happened to, it's been one or two or several. That gives our office jurisdiction to go and sue the contractor for their illegal, deceptive, and fraudulent business practices. And the only way we're going to know about that is consumers who file complaints. So I would encourage you to file a complaint. If it's a one-off deal, it's one contractor, there's no other complaints. It just happens to be that this contractor violated the law, the home improvement contractor law. Our office wouldn't have jurisdiction unless we can show repeated or persistent. But your complaint that you file with us could be the first of several that we may get against this contractor. And it may also be that we don't have other complaints against this contractor, but it might trigger, not saying that it will, but it might trigger a further investigation by our office, where we've had situations where we received the one complaint. We said, this sounds a little odd. This probably isn't the only victim that would have suffered as a result of this business. And it could cause us to inquire of that contractor to provide us with information on other jobs that he or she may have been doing, and that we may find out that there has been more than just this one violation. And that would trigger, again, our repeated and persistent jurisdiction. At this stage, I think I'm going to put it out there to see if there are any questions that consumers have put in. Sandy, I'll send it back to you to see if there were any questions.
Great, thanks, Mike. There actually is a question in the chat from about 10 minutes into the presentation. Would installation or repair of on-site septic or drinking water wells also be covered?
Yes. Yes, that's part of the home. So it would be. So those repairs to wells or septic should also be in writing. And all the other provisions that we talked about would be covered under the home improvement contractor law.
Does TCEH that submitted that have any follow-up question on that, or are you good?
Well, yes. Hi, my name is Becky Sims. I'm working in the on-site wastewater treatment permitting program here at the Tompkins County Health Department. And one of the reasons we're interested in, finding out more about this is because we work directly with homeowners, but of course they have the choice of contractor, to install the project, but according to our specifications. So we're kind of involved, but also there's room for the homeowners too. So just trying to get a better understanding of who has what responsibilities when homeowners are undergoing these kind of major installations.
So the contract is between the homeowner and the contractor. That's going to put in a new septic system or drill a new well or something like that. So all these home improvement contractor restrictions are on the contractor to provide this written contract to the homeowner. Now, the homeowner is obviously not going to be aware of the particular restrictions of Tompkins County Health Department, but the contractor is under an obligation to do a good job, to do a job that is reasonable and that complies with giving the homeowner what they contracted for, which is a functioning septic system and well water. And so a violation of Tompkins County Health in the installation of the septic system or drilling the water would be a breach of that contract that the contractor has with the homeowner, and subject to whatever damages the homeowner may sustain. That answer?
Yes, thank you. That's really helpful. And this is really good context that I think will help us be able to better assist and provide, good information to people that are going through this process. Thanks.
Great. Sandy, any other questions?
I don't see any. So I think we can, last call here.
Do I have a chance to put in my editorial?
Sure, go for it.
Okay. I wanted just to let people know, we have been putting on these consumer issues programs for almost 25 years. I've been doing this. And I can tell you, I was just thinking about this the other day. I can probably count on less, I'd say one hand, but at least less than two hands in the 24 plus years of 12 months a year. I can probably count on less than, I would say probably less than a handful that we haven't been able to put on this particular program. And I want to extend my thanks and earnest compliments to Tompkins County Cornell Cooperative Extension for their hosting us and allowing us to put on these programs. I know that I'll speak for the Attorney General, of which I've worked for 6 during this 24 plus year period of time. And I know that Tish James really appreciated the access that Cornell Cooperative Extension has provided to our office so that we can get the information out to the consumers. But as it turns out, this will be the last consumer issues program. It's unfortunate, and I will miss everyone at Cornell Cooperative Extension, even the ones that I see virtually, but for the first, 22 years of it, when I was out there every month to visit and chat with everyone there, from Ann Gifford to you, Sandy, just all of the people I've dealt with. It's been fantastic. I've really enjoyed it. I hope we've been able to give out information to the residents in Tompkins County, as well as outlying areas that may be viewing these, that they understand their rights and that they know that our office is still here. If they have a consumer complaint, anything related to a business where they may have an issue, they can feel free to contact our office. We'd be glad to help. I've really enjoyed it. I miss seeing everybody, but I want to thank you again for all your hospitality and hosting us. And it's been a great relationship over the last 24 plus years.
Thank you, Mike. We've enjoyed working with you too, and we really appreciate your willingness and the Attorney General's office's willingness to contribute your expertise to this and bring it right into the community. I think it's been a really valuable program, and we'll hope that we can return to offering this again in the future. It's been great working with you. Thanks, Mike, and thanks everybody who joined us today for this presentation. For more information about consumer issues, please visit our website at ccetompkins.org. Thanks so much.